Hello and welcome to the Law Lab. Here, we dissect and unpack everything legal. My name is Jacqueline Faopuku, and anytime you see me on your screen, you know we are about to discuss contract law. So far, in our discussion in contract law, we have looked at how a contract is formed. My colleague Deborah Emisa has started with you vitiating factors. As you've already known, vitiating factors are factors that make a legal contract unenforceable or make it voidable or void ab initio. I would like to give reverence to my other colleagues who have been taking us through contract law. We have Aaron Esiedu, Deborah Emisa, and Daniel Ojo-Minta. Today, our discussion will be on misrepresentation. That is one of the vitiating factors of a contract. First off, I would like to draw your attention on what misrepresentation is. Misrepresentation is a false statement. That means it has to be a statement, but then the statement made is a false statement. It is a false statement of fact made by one party to another with the intention to induce the other party to enter into the contract, and it therefore induces that party to enter into the said contract. For misrepresentation to be operative, there has to be a statement of fact. That statement of fact has to be false, and it is done or it is said with the intention to induce the other party to enter into the contract, and the other party relied on that false statement to enter into the contract. This means that had the false statement not been made, the other party would not have entered the contract. How can misrepresentation be manifested? Misrepresentation can be manifested either by conduct or by words. By words, you state it. You tell the person that A or B is what I want us to do. But then it turns out the A and B statement you made is a false statement made to the other party with the intention that the other party will be induced by this statement and will enter into the contract with you. And another means is by conduct. Conduct can be your bodily conduct or can be disregard of certain statement that you made that you should have corrected before entering into the contract with the other party. There are instances where statements will be made but may not amount to misrepresentation or may not amount to representation of fact. Example of these actions or statements are known as 1. Statement of opinion or intention. When we talk about statement of opinion or intention, it simply means that you are telling someone what you think an act ought to be and not what it is. Statement of opinion does not constitute operative misrepresentation because there was no reliance by the person making that statement and it was made without the intention of inducing the other party to enter into the contract. In the case of Bissett versus Wilkinson, a seller who intended to sell his farmland to a purchaser told the purchaser that he believes or he thinks that this farm can hold 2,000 sheep. But when the purchaser bought the land, he was very much aware that the seller had no idea about what he was saying and could not rely on it. When he bought the land, he could not rear the sheep on the land and therefore sued. The court held that it was a mere statement of opinion, and mere statements of opinion do not amount to misrepresentation or representation of facts. Another statement that can be made and does not amount to misrepresentation or representation of fact is mere puffs. Mere puffs are used in advertisement. Example, when you see Nanama on your TV screen making an advert for Hisense TV or Hisense product, you must have in mind that whatever she is saying is not trying to induce you to enter into a contract with Hisense, but it is convincing you to either purchase from Hisense and not necessarily to induce you to enter into the contract. Usually, mere puffs are expressed in vague terms. Vague terms in the sense that there is no belief in the function that the term or the statement made will be done or will not be done. This was held in the case of Dimmock versus Hallett. The court stated that mere puffs do not amount to operative misrepresentation. One may ask, if a person enters into a contract or wants to enter into a contract with another person, but the other person do not make any response or do not give any response to the other party, does it amount to misrepresentation? In the legal sense, does silence of the other party amount to misrepresentation? The general law is that silence cannot be treated as misrepresentation because there was no utterance of statement or conduct that should have induced the other party to enter into the contract. But there are situations where the court will treat your silence as a form of misrepresentation. This is known as the exception to silence as a form of misrepresentation. The first exception is that when your silence distorts the truth of the statement you made initially, the court will hold your silence as a misrepresentation. What does this mean? It means that you may have told the other party a certain truth, but that truth in the course of business or in the course of your contract amounted to be false subsequently. Meaning, when you were entering into the contract and you made that statement, you made a truthful statement, but as the time went on, the statement became true, but you did not inform the other party about the untruthfulness of the statement later on in the contract. In the case of Wade versus O'Flanagan, in this case, the defendant intended to sell his medical practice to the plaintiff. When he intended to sell, he told the plaintiff that the yearly income from which the yearly income he made from this medical practice was 2,000 euros. But later on, it reduced to 5 euros, but he did not inform the plaintiff about the reduction. The court held that he not informing the plaintiff about the reduction of the medical practice and keeping silent about it amounted to misrepresentation. Hence, the plaintiff was entitled to rescind the contract and also claim for damages. Another exception is that when your silence amounts to partial disclosure. We have already come to know that in formation of a contract, you must ensure that you disclose all relevant information that are related to the contract to the other party, for the other party to make a decision as to whether or not they will enter the contract with you. Here is the case that you will decide to tell part of the relevant information to the other party and decide to keep the most relevant part to you. Although you have stated the relevant part of the contract, you decided that because of the most relevant part of the contract, if you tell the other party, he or she may not enter into the contract. So you decide not to tell the party. The court will hold that this will amount to operative misrepresentation, which will enable the other party to either rescind or claim damages from you. Another exception is contract of utmost good faith. These type of contracts are seen in insurance where the other party has all the necessary information of which he must make available to the other party but does not. Due to this, the court will hold that this was not a contract made in good faith and therefore amounts to misrepresentation. In our next video, we'll be discussing the types of misrepresentation, of which they are fraudulent misrepresentation, innocent representation, and negligent misrepresentation. Thank you for joining our discussion on misrepresentation. Once again, here is the Law Lab, and we dissect and unpack everything legal. I continue to urge you to subscribe, comment, and share with your other colleagues in order for them to know what misrepresentation is. Thank you.